The Places of Worship Act of 1991 was enacted to make sure that places of worship will remain in the same nature as it was on the 15th of August 1947, and it also prohibited conversion of the places of worship. The law has been in news quite a bit over the last few days, not just because of the violence that took place in Uttar Pradesh's Sambhal following the court order that allowed for a survey in a 16th century mosque there, but also because on the 12th of December, the Supreme Court will hear the Gyanvapi Mosque Committee's plea that has challenged a batch of petitions that are even questioning the validity of the Places of Worship Act itself. Joining me now today is Supreme Court Advocate Shahrukh Alam, who will talk to us about the Act in itself, but also what it means and what is the message that the courts and the ruling coalition have been giving to minorities in India. I want to start with asking you for your thoughts on what Justice Nariman recently said, that the Places of Worship Act should be applied to stop more civil suits against mosques and dargahs. Do you agree with him?
I absolutely agree with that. I absolutely agree with that. But with two riders. Even in the last week, 10 days, there's been two incidents that have caught my attention. You must have heard of this news that came out of Moradabad in UP, where a Muslim doctor couple made a legal registered sale. They bought a property from some person. It was a legal sale, it was registered property. And then there were large scale protests asking for that sale to be reversed, saying we don't want a doctor, we don't want a Muslim couple living amongst us. So they were legal owners, they had legal title, private property, and people are saying we will not endorse the sale, we will not recognize the sale, take it back. Then in Uttarakhand in the same week, in Tehri Garhwal, there was a Muslim lady who was saying her Friday prayers in her own house, in her own private property. And she was then visited by a mob of enraged people saying, we will not allow this. So here are two incidents where Muslims own private property. This is legally owned private property, these are legal title deeds. And that is being questioned and that is being challenged. So they're saying that you can't even pray in private spaces, leave alone public places of worship. You can't even say your prayers in your own private property. So as a claim to this land, as a problem of belonging, this has gone beyond public places of worship. This has gone beyond Places of Worship Act now. Muslims are being challenged in their own private spaces now. So that is the scale of the problem, right? You'd also remember that of late, especially during Hindu festivals, processions often stop outside mosques and outside private properties. And a few angry young men from the crowd often make their way into the Muslim private properties and often install saffron flags there. So it is an assault now on private property, not just on disputed, legally disputed or historically disputed public places of worship. So my rider is that this is now at a scale beyond this act. So of course this should be read at every district court. This should be talked about a lot more. But we need to recognize that the claim now is not just historically or mythologically disputed public land. The claim is of a different order. The Hindu nationalist claim now is that we have superior entitlement to this land. We belong to this land and you do not. So it's now a claim of original inhabitants, it's a claim of original belonging, and it's a claim that now derogates others' equal citizenship right. Right? So it's a very different claim now that is being made, and we need much more protection, not less. We need the Places of Worship Act, but we also need a very clear statement about equal citizenship. We need to invoke criminal criminal law sections to to, to sort of punish these people who encroaching upon Muslims' private properties. That's the first rider. And the second rider is that sometimes people say that this is really a political question now. It's a political question which is trying to reinterpret history, restructure citizenship, and restructure the nation. And it's about reinterpreting colonization and all of that. But to my mind, and I think that the courts have also used this implicitly, if not explicitly, they've used it implicitly to evade a straight answer to this pattern of abuse of process. And they're evading it behind the doctrine of political thicket. They're saying it's really a political question. But to my mind, it's a constitutional question. It goes to the root of our constitutional rights because it really defines citizenship and it defines the democratic, secular, modern republic that is India. So with these two riders, I think the places of worship should be read. Yes.
I want to talk about the incident that happened in Sambhal. Do you think the court allowing permission for an inquiry or a survey directly led to the violence that resulted in the death of at least 4 people?
I think it was certainly one of the factors, but there were two or three other very important factors. The one other important factor was the complete lack of accountability with which police, and especially police in Uttar Pradesh now, responds to any kind of dissent or any kind of resistance on the streets. It is trigger happy because it acts with impunity, not just in this case, but across the board, with protesters, with dissenters, with anybody who's not showing complete acquiescence to government policies. The second factor is popular public opinion that was completely against, the stereotype of the Muslim stone pelter. And popular public opinion is that if people are protesting, and especially if Muslims are protesting and pelting stones, then they deserve this kind of firing upon. And that is in stark contrast to what happened in Bahraij, for instance, which was again similar. There was a procession that was being taken at some religious occasion, and one angry boy went into a house, into a private property, which had a green flag on top of its terrace. He took off the green flag and planted a saffron flag, symbolic, and tragically then lost his life. He was fired upon. Uh, some narratives also say that he was first beaten and then fired upon, tragically lost his life. He entered a private property. He was the aggressor there. But public opinion was squarely with him. Everyone felt that it was wrong that he died, and justifiably so. I agree with that opinion. And people were arrested for that. The police immediately went into motion. People were arrested, booked, etc. But somehow, public opinion in this case, in the Sambhal case, is not with the protesters. It's not with those who were saying, please don't come into the mosque and do a survey without first taking us into confidence. And I also wonder about this, this complete disparate public opinion. You're with the aggressors in some cases, you're not with the aggressors in other cases. But yes, to answer your question more directly, the court did seem in a huge rush to order a survey without hearing the other side, without issuing notice. Nobody was heard. The plaintiffs moved the order survey on the same day, the same evening. And the Advocate Commissioner actually went also on the same evening and conducted a preliminary survey. And there was no disturbance on the first day. But 4 days later, they again went in the morning. And this time they went accompanied with the police force, also with advocate commissioners, but also with parties, the plaintiffs to the suit. They were also there as part of the survey. And they were also raising slogans. And the other side was not taken into confidence, and the other side did react. And the other side did indulge in some kind of misdemeanors and petty violence and stone pelting. The police, for their part, did not follow the procedure that's laid down for crowd control. They fired into the air. The police are now, of course, claiming that the deaths did not happen because of police firing. The deaths happened because people fired at each other, apparently.
Right. You were right in mentioning that the police didn't take the other side into confidence. And I want to pick on the fact that the court also didn't give enough time and an opportunity to both the mosque management as well as the clergy to challenge it or even present their side. In this backdrop, there are people who are questioning the very validity of the order. What are your views on this?
I did also mention that the court seemed in a huge hurry to pass that order. They, even as a principle of natural justice, they should have heard the other side first before even passing preliminary interim survey orders. That was totally uncalled for. But as a point of law, the survey itself seems untenable to me, because what the Places of Worship Act does is it freezes the character of any place of worship as it stood on 15th August 1947. So, whatever happened, whatever allegedly happened before 15th August 1947 is of no consequence. Because the logic is that on 15th August, we now look towards the future, not towards whatever alleged historical wrongs or mythological wrongs that happened. So the survey itself is untenable, according to me. But we know where it's coming from. It's coming from the oral remark in the Supreme Court, which, according to me, again, was an obiter in a case, in the facts of that case. It was an obiter, it was a chance oral remark. It's not part of the orders that were passed on 20th May 22. So it's not a precedent. It has no value as precedence. But what the court said in the facts of that case, in the facts of the Gyanvapi case, was that a survey does not necessarily mean that you're changing the character of the place of worship. You're just exploring, maybe as an academic exercise, to find out what was, which is neither here nor there. And even in the facts of that case, I don't think it stands to reason. But then to follow it as precedent in case after case is completely legally untenable.
I agree with you on that. But that said, isn't it a very significant observation, especially who it came from? The fact that it came from the former Chief Justice of India, Justice Chandrachud. And this kind of makes, it gives a loophole, a grey area, if you may, for many other petitions to be filed. And that is exactly what has happened. Because if you do conduct a survey, even though you do not seek to alter it, it can lead to violence, as we've seen in so many cases, isn't it?
Absolutely. But legally also, no matter who says it, if it's an oral remark, if it's thinking aloud, it's not part of the order, it's not part of the reasoning, it's not part of the ratio decidendi, it's not a precedent. So lower courts, the trial court, and the high courts, in my humble opinion, are wrong to treat it as some kind of precedent. It was said, and again I repeat that it was said, I think, unreasonably in the very narrow facts of that particular case that was before the court. And the court, even in that case, didn't deem it fit to actually record it as reasoning in their order. It was a chance remark, it was an oral remark. Yeah, yeah, but of course it has a lot of narrative value. It carries a lot of weight. It gives people a way in, wrongly so, I think. Sorry, let me also add to this. Even this kind of reasoning, even to say that it's an exploration of what was, uh, why should it accrue only to Muslim places of worship? What if I want to investigate what was under the Supreme Court of India? Is that a tenable request? Would a survey be possible in such a case? What if I want to do this to somebody's private property? Is that a tenable request? And if it's not, then why should it accrue to places of worship?
One of the things that they have said in the plea is that anybody can raise a rhetorical question and go and ask for an inquiry. Now, can't this also apply? While you're telling our viewers about what this case is about, my additional question is, can't this also apply to Hindu sites of worship, right? There can be somebody from the Buddhist community who can come and say that there was, in places like Bodh Gaya perhaps, or some other part of Uttar Pradesh, they'll come and ask that there was a Buddhist site underneath a Hindu temple. So I want a survey of that. So where does this end?
Well, it's also the dynamic of power is at play, right? I started with that. It's now not limited to any historical legal dispute even. It's bullying. It's a show of strength. So in this scenario, it will not happen to other sites. It will only happen to Muslim sites, as it is happening to Muslim private property. So it's also a show of strength. It's about the social political dynamic of power. But legally, reasonably, it can happen to any site. It can happen to private property. If your logic is let people just explore, that then it can happen to monuments. It can happen to all kinds of places. It can happen to the parliament. It can happen to hospitals and schools. It can happen to your house or my house. But I also want to touch upon something that you hinted at, which is it can happen to Buddhist sites, of course. Now, the cutoff date that has been chosen in the Places of Worship Act is 15th August 1947. And that's a significant date. That's a date where the modern republic comes into being. Not technically, it came into being on the 26th of January 1950, but that's when we become independent. And that's been chosen as the cutoff date where every person is an equal citizen. Now, the challenge to the Places of Worship Act says that this date is arbitrary. If at all you want to set a cutoff date, let it be the year that the Sultanate, the Delhi Sultanate, came to power, because that was the year when things began to go wrong. Now, that argument is also a very remarkable argument. It's an disingenuous argument because, again, it makes the claim that Hindus in this country have the original claim to belonging. But it also derogates the rights of Adivasis and the animistic religions that predate Hinduism. It just negates those rights. It also obviously derogates the rights of Muslims and says that all of you were invaders, all of you were colonizers. So to even argue that that date should be set back to the Lodi period or to the Sultanate period is disingenuous. But that is the claim. That is what the argument is. So what happened to Buddhist sites? What happened to Adivasi sites? What happened to animistic religions? Don't seem to matter. It seems to be a fight between the Muslim colonizers and the Muslim invaders and the Hindu religions that existed before them, which is historically not true.
Is it right to call it judicial overreach that the law is in place? It hasn't been repealed yet, neither by parliament nor by any court. So, in view of that, there have been so many courts that have allowed surveys to be conducted. Is it right to categorize this as judicial overreach?
It's not an overreach. I think it's complete judicial withdrawal uh, from a very sort of disputed terrain. It's a complete withdrawal of the rule of law. This law is in place, and you're withdrawing from the rule of law, and you're saying, "Yeah, do as you like." It's not an overreach. It's a withdrawal completely, like there has been withdrawal from these other arenas where there is bullying, there is encroachment, and the law says, I mean, the police and the state say that we can't do anything, or they don't seem to be wanting to do anything.
On 12th of December, the Supreme Court will hear the Gyanvapi Mosque Committee's plea that is challenging the batch of petitions that are questioning the validity of the Act itself. Can you tell our viewers a little bit about this plea in itself and also the context in which it was filed?
So, the Places of Worship Act freezes the character of the place of worship as it stood on 15th August 1947, right? And it says that after that, you can't now bring a claim to change it. And all suits, all appeals, all legal proceedings will abate. Which then means that if there was a claim pre 1947, if there was a dispute pre 1947, even that will abate. Even that doesn't now exist. So if there was a dispute in antiquity or in the medieval times or before independence, that is not relevant anymore. The only thing that is relevant is if you bring a claim and say that yes, this was a temple in 1947 or this was a mosque in 1947, but in 1948 it was taken away from me and its character was changed post 1947. Now that's a very limited claim, right? But the Gyanvapi claim is that we were worshipping in the outer precincts, along the outer wall, and in the tehkhana, in the basement, till 91 or till 93, and then we were displaced after that. So their claim actually pertains to post 1947. But it doesn't pertain to the main mosque, it pertains to the outer boundary, pertains to the basement of the mosque. Now, Justice Nariman had also said that a similar thing had happened in the Babri Masjid case. In the Babri Masjid case, the initial claims were about the outer precincts of the Babri Masjid. And these claims were first made in around 1857 or so, when the outer precincts and the inner precincts were divided by a wall. The Hindu claims pertain to, not the Hindu claims, that I don't want to use that word, the claims, the Ram Janambhoomi claims pertain to the outer precincts. But Justice Nariman pointed out that actually the Supreme Court clubbed the two, clubbed the claims to the outer precinct and made it a claim to the composite whole. And Justice Nariman said that that itself was disingenuous, that was wrong, because the claim was only about the outer precincts. Now, similarly, in the Gyanvapi case, the claim is about the outer wall and the tehkhana. But the survey treats it as a composite whole. It treats it as a claim to the whole mosque. And that's the same pattern being repeated. So you bring in a claim where you say that I was doing this up until 93, but I was only worshipping in some part of the larger precinct. But then your claim becomes a claim to the composite whole, which again I think is untenable under the Act, but that's how it's been framed. So that's the claim. The defense, of course, is that this is not allowed. This is already barred under the Places of Worship Act. That in 1947, the primary dominant character was that of a mosque, and so it should remain, because that's the protection that's been offered by the Act. And then on facts, of course, there's a dispute. There's a dispute on facts where the mosque committee is saying that what you're saying is not accurate. That's not true. So there's a dispute on facts as well.
Right. If we can look at the context in which the law was passed in 1991, right? This is around the time when the Rath Yatra was going across the country, in wake of which there was a lot of communal violence too. And if I can quote the Home Minister at the time, his name was Chauhan, while introducing the bill, he had said that the government did not intend to create new disputes and to rake up old controversies which had long been forgotten by the people. Can you tell our viewers what was the thinking behind passing this bill and what was the context to it as well?
You described the context. I think the Ram Janambhoomi Babri Masjid dispute had sort of taken over the country. There was a lot of polarization. There was communal tension. There was communal strife, and I think the leadership of the time feared that if this is repeated, the country will come apart. So this was really meant to be a protection from, like he said, from reopening the alleged wounds of the past, I'd say, uh, from continuously reinterpreting history and trying to poke at those alleged wounds. And I think this act had hoped to put a stop to that and then start to look towards the future.
And in view of this, the fact that so many people who are a part of the ruling coalition, who are part of the government, currently are calling for more and more such surveys, more reclamation, as they say. What does that say about the worldview of those in government today?
Well, they want to make that claim about belonging, and they constantly harp towards a allegedly disputed historical slash mythological past, uh, which derogates the rights of other minorities, of Adivasis, of other communities, and basically it's a claim to being the original inhabitants, and this continuous raking of the past on disputed facts helps that cause. It keeps everything alive all the time. So it then becomes a campaign, it becomes a narrative. And I think it feeds into the Hindu nationalist ideology, which is the ruling coalition's ideology at the moment. But since you'd asked me this, I wanted to also I'm reading these sentences from the Muhammad Siddiqui judgment, which is the Ram Janambhoomi temple's judgment, and it says that and I'm reading from, I think this is DYC's part of the judgment. There is a purpose underlying the enactment of the Places of Worship Act. The law speaks to our history and to the future of the nation. Cognizant as we are of our history and of the need for the nation to confront it, independence was a watershed moment to heal the wounds of the past. Historical wrongs cannot be remedied by the people taking the law in their own hands. In preserving the character of places of public worship, Parliament has mandated in no uncertain terms that history and its wrongs shall not be used as instruments to oppress the present and the future. So that was the thinking behind it. I also just want to put another rider here. I think history and its wrongs should also be read with all the nuances that it deserves. The historical wrongs were not between these two communities alone. The historical wrongs were much more layered than that. It wasn't the wrongs committed by the Muslim invaders on the Hindu natives. Uh, Historical wrongs are more dynamic, more layered. There were wrongs. There were wrongs across religion. There were wrongs across caste lines. There were wrongs across religious lines. All kinds of them. So even this is simplistic. History and its wrongs.
I know you're pressed for time, so I'm going to quickly sneak in one last question. There is already a law in place, but despite that, we've seen these claims going to court, and in many cases, like we already discussed, orders being passed. It's happened in Karnataka, the claims coming in Maharashtra, of course, parts of Uttar Pradesh. What can be done to make sure that the existing law is understood in letter and spirit?
What can be done? I think we this case will open in court this week. The constitutionality of the Places of Worship Act, and hopefully once that is clarified, uh, there some of this will be put to rest. I'm hoping, but I'm also aware that it's gone outside now the realm of law. What I described to you in my opening statements is not within the realm of law. So we need something more explicit. We need something more definite, which conveys to the minorities and to the authorities that you can't go on like this. This is outside the realm of law already. I described to you the Gyanvapi plaint, where they've at least taken the plea that they were worshipping post 1947, and their worship was disturbed post 1947, so they're not covered by the Places of Worship Act. But I'm not sure that the latest petitions, which include the dargah at Ajmer, which include the Jama Masjid, have even included those niceties. They're saying we want it back because it belonged to us in the 16th century or the 17th century, right? So even those niceties are not there in the later petitions. That's all.
Right. I thank you for joining, and of course, we will continue keeping a close track of the court orders and also what happens outside the court. Thank you.
Thank you, Pooja.